Let us pray. Almighty God, we ask for your blessing and wisdom upon this Parliament. Direct and prosper proceedings, the peace and welfare of people of Solomon Islands. We ask this in the name of our Lord and Savior Jesus Christ. Amen.
Thank you. Parliament resumes.
Asking and answering of questions.
Question number 60. We ask for the Leader of Opposition and MP for Auke Langalanga.
We, Mr. Speaker, and Laui Pongpong. Sir, question number 60, let me call on Minister of Mines. Let me read also. Was an environmental rehabilitation bond deposit made by the license holder and contractor in the now closed Renal bauxite mining lease? And two, if so, how much? And B, how was it used? Thank you, sir.
Thank you, Honourable Minister for Mines, Energy.
Thank you, Mr. Speaker. I would like to thank the Leader of Official Opposition and the MP for Auke Langalanga for that very important question. Mr. Speaker, environmental bond, it's a very important practice when practice to it's regarded as best practice lo sa sektaya. Lokis blame in Solomon Islands, the current laws that IMI garem, unfortunately there are no specific provisions even though the current Mines and Minerals Act here, as well as the Environmental Act here, even though there are specific provisions where we require payment of an environmental bond. So to answer the question, Mr. Speaker, there has been no environmental bond paid here, this for a case. However, the government recognizing this one as a grey area in this industry or this sector. And the Ministry of Mines, together with the Ministry of Environment, we are working on this, doing through our legislative reform program to transform the sector. This will, under the current reforms, this will new Minerals Act here. There's a reference to financial assurances where Bahemi require them now, or companies who pay that one. That's under part 3, section 2, financial assurances, we require companies for making bond payments to government. So that time we got incurring environmental damages to the sites that are doing mining lohem. About that money can be used for rehabilitation, even if we got the operation is finished, that money will be there for environmental rehabilitation. And also as part of legislative reforms to transform the sector under the proposed environmental bill, it explicitly provides for environmental bonds under relevant sections of that environmental bill, clause 86, we have referred to that one. Also, government have looking this one, it's a very, it's an area, it's a gap, current legislative framework, and we are working on it. We are working on a policy to be brought to the cabinet, environmental bond, the Ministry of Mines together with the Ministry of Environment, and that policy here will pave the way for the calculation of the environmental bond. But I'm also outlining now the framework on which the bond can be implemented. Under the policy, Mr. Speaker, it will be integrated into the mining amendment regulations and will be linked to the Environmental Act 1998 and the Mines and Minerals Act 1990. For just for the information of the House, under this policy direction, the Director of Mines, in coordination with the Director of Environment, Tufalana will have joint authority to determine and assess the appropriate bond amount and mechanisms to be put in place. And the bond shall be lodged prior to the commencement of mining operations and maintained throughout the project life. So to answer the question, no any bond payment have done, but it is a gray area where we are working on at the moment to ensure that there is a provision for that, even with the current regulations and legislation way in Garen. Thank you, Mr. Speaker.
Thank you, Honourable Minister. Honourable Leader of Opposition.
Yeah, sorry, Mr. Speaker, me, hearing this one, me like Karayana. This is a terrible state of affairs. This is negligence of the worst kind. Unfortunately, Minister of Fisheries no stop, but he's been Minister for Mines for an extended period. The fact that Minister Hemisei regulations under existing law can address this issue means it should have been addressed years ago. Me assuming no more that something Hemi has already been addressed. Hemi no good that issues here me will raise him in questions here before government Hemi kick around for addressing time question have come out on notice. But this is negligence of the worst kind. In last time Goldridge we had issues with the tailings dam. And them overflow for go inside Lomo, water go downstream complain all the way. That already, we're talking about 10, 15 years ago. That should have highlighted the need for this bond there to all mining operations right across the country. And yet we have not learned from that experience, Mr. Speaker. Me, you go to Renault, West Renault, and you see the holes that these guys have left there. Hey, man, sorry something here. And to make matters worse, or it is packing or heavy equipment here, no more rust lo there. So not only or digging place here, no rehabilitating, or throwing waste lo get lo there more. And it's just really a ridiculous situation. To say that there was nothing in place all these years. Me assume that the standard practice here, bond must go in here. But I have no go in here, man, karagay. You mean really the government has been negligent over many years, not just this government, this one, unfortunately, over many, many years. And me hatlo me baro pain for her in this one. And although the question is specifically with regards to Renault, obviously, that absence of the bond right across all the assets. And the issue highlighted by the Renault operations, or at least one of those operations, is both the licensee and the major contractor about defunct voluntary liquidations or all same. So you can't go after them either. I mean, it's either we're negligent or we have no idea what we're doing. And they're just riding roughshod over us all these years, Mr. Speaker. Obviously, I mean, not just Matalo, this government, been for a while, so something we must respond to, and not something for political, we must respond to, because then deal with our environment, and of course, people believe me where survive law get the environment here. Mr. Speaker, thank you.
Thank you, Honourable Minister, Leader of Opposition. Honourable Minister.
Thank you, Mr. Speaker, and we thank you, Leader of Opposition, for the comments. Yes, indeed, this one gap will exist, and it's unfortunate that that's taken us a while. But I would like to assure this House that this federal government will be the first one to come up with a policy for we must put in environmental bond there now. And the policy will come before Cabinet is already finalized. We will take them come. And we will ensure that policy by putting into place environmental bond, which will be abide to environmental international best practice in this regard. But me noting now, comments below leader of opposition, it's something that we all recognize, and GNAT is working seriously on this to ensure that this situation will not continue. Mining sector is emerging, it's new, and we like for starting well with all these international based standards properly in place and implemented the way we all expect them to be. Thank you, Mr. Speaker.
Thank you, Honourable Minister. Honourable Leader.
Thank you, sir. So, if also in the case below Renault, where Noini Bond Lohem and the environmental degradation and destruction is very, very large and very obvious, who picks up that liability? Who now by meeting? Thank you, sir.
Thank you, Honourable Minister.
Thank you, Mr. Speaker, and thank you, Leader of Opposition, for that supplementary question. In fact, despite the non-payment of environmental bond under mining agreement, there is obligation for Katamas rehabilitation to environmental damages. And that obligation is a legal requirement for the companies for Masdrim. We will ensure that this provision is fulfilled, that the agreements were existing to allow for the operation for and void. Thank you.
Thank you, Honourable Minister. Honourable Leader of Opposition.
Yeah, in this specific case, sir, what companies here? No more now. I mean, the company contractor were doing work here. Company, I mean, no longer registered. And the licensee, I'm not sure what the legal status is of that company, but I have no got any assets now. Last time, Fisheries Minister time we talk about 33 shipments. Yeah? So how now are you imposing our contract liabilities on them? Sir, thank you.
Thank you, Honourable Minister.
Thank you, Mr. Speaker, and thank you, Leader of Opposition, for that supplementary question. Yes, the issue surrounding bauxite law and well has been quite challenging. We know all the everything will happen in Kamkasan this time, and we are hoping that with the establishment of the Commission of Inquiry, a lot of these issues will have answered. Their liquidation and all these things here only added up to the challenges that is posed to us as a government, as people, and as a country. What now the gaps within the sector where, as we go along, we must find ways to ensure that that not happen again, that not happen back more. The legislative framework, the legal framework we work on, makes a lot of gaps over there, where if we don't patch him up, we'll continue to face challenges like this. We all learn from the experiences that we, as a country, as a government, as a people, we go through with these various operations here. The best we can do is to identify through the establishment of a Commission of Inquiry, where I have earlier on updated Parliament Lohem, but also ongoing legislative reforms to fill up those gaps. Thank you, Mr. Speaker.
Thank you, Honourable Minister. Honourable MP for West Harare.
Thank you, Speaker. Thank you, Minister, for enlightening House Law this question and matter. Me like for joining little hard lem me karaya, but me hard lo me hem nam now. Hem hard for karaya now, Minister, for long time to see me koko obam this one and big neglect. So me hard for karaya now, awesome. Like for karaya, but hard. My supplementary question, Mr. Speaker. Minister, you mentioned about financial assurance to follow Minister, Environment and Mines to follow hem choice to follow or hem must. Then there is, as you highlighted, absence of this legal requirement law rehabilitation bond. Yeah? To follow must make him or hem choice to follow no man. Thank you, Mr. Speaker.
Thank you, Honourable Minister.
Thank you, Mr. Speaker, and thank you, MP for West Harare and Chairman Blue Beach and Legislation Committee for that supplementary question. Okay, to follow something. First and foremost is the policy. where baham come in, policy baham come in, by me as soon as I'm passed or endorsed by cabinet, it will be part and parcel of our current legislative framework, whereby he also mentioned him coming regulations and implemented along with the current Environmental Act as well as the Mines and Minerals Bill Act law where this time. The second one, the policy will also guide us into the legislative reform program where under this minerals bill when before Parliament, the financial assurance it's a requirement. Ota must pay na. And under the environmental bill, the proposed environmental bill, it explicitly make reference to environmental bond, a legal requirement that the companies operators must pay now to avoid what you may already experiencing. So for the interim, we will have policy direction, we will have coming, and then in the long term into the future, we have the legislative reform program whereby make sure that environmental bond is a legal requirement by all operators, investors, for this sector, or that must fulfill him. Thank you, Mr. Speaker.
Thank you, Honourable Minister. Honourable Leader. Sorry, Honourable MP for East Joyce.
Mr. Speaker, thank you very much. Just maybe a related question about just the update on the government's submissions for compensation related to the oil spill Longo Breno years ago, maybe a 20 General Survey. So we are updating House Law.
Thank you, Honourable Minister. Honourable Attorney General, sorry.
Thank you, Mr. Speaker, and thank you, MP for East Joseph, for that question. In terms of the claim, we have applied for service out of jurisdiction, High Court, and High Court granting, and we've sent the claims and everything all Korea. So it's Korea, Caribbeans, and Hong Kong, different jurisdictions. So Ota lawyers waka for me on pro bono Australia, DLA Piper. They have offices around Ota areas of jurisdiction, yeah? And so they are assisting us in trying to get this fella claims saved, and once they are saved properly in accordance with the rules of law at jurisdictions, yeah, then we'll start maybe wait for come up with him appearance then we'll start with the next part of the process. But it's service out of jurisdiction that is taking a little bit time. But we've done that and it's on process. Thank you, Mr. Speaker.
Thank you, Honourable Attorney General. Thank you, Honourable Leader of Opposition. Anything more?
Yeah, sir, I do wish to thank the Minister for Mines. Unfortunately, got issue in raising a new man no more, so here also have no dim work a blame, but man no dim work I no stop there. Minister of Fisheries here. Minister how many years now? Minister of Mines here. So bara useless to now man. Man. Bara useless here, bara. You may laugh, but I'm no good chance to myself. I mean the poor Renaultese oil spill more. Royalty no pay more, take shipments here more. We got big mighty holy stuff behind Logat House, Logat more. Mr. Speaker. I'm no good something to say, people blame me, and that can happen anywhere in this country. But what's sitting out low deaf ears too. And to say that this neglect something in me overlooking, no him no more, him barawa. Him long time too much, and we've had years and years of experience with Goldridge and the environmental issues there. So really, there is no excuse for this neglect. And the Minister of Foreign Affairs, Member of Central Walkana, been releasing this matter specifically with regards to Goldridge. So I'm really happy that finally the Minister and Ministry are addressing these issues, and the outline of the policy is a good one. You must make sure Lord get something heavy taken into account, and obviously the oil spill liability. We have to domesticate. We have to bring in law, sir, to make sure liability him go and then stick loget money and then him enforce quickly. We're pursuing these things out of jurisdiction here. It's going to take maybe another 10 years or also, but the impacts has already happened, local communities, believe me. So this is a sector that's on the cusp of takeoff here. And the kinds of characters that are swirling around, they're like vultures, you know. They're looking for a quick buck. And they're swirling around, and our lack of robust regulatory framework only makes us even more vulnerable and our people worse vulnerable. So we really have to step up our game. The minerals bill, on this matter, Hemi Garam good provisions. There are other issues inside the minerals bill here too, where we must fix him so we don't repeat the problems we've had with the logging sector. You know, the issues of bauxite go, we have no reports on cobalt or alumina and other associated metals. Same problem happened law. Nicole hem go ahead law Israel so far. We're not addressing those issues, but they're big issues, big losses to government and to landowners, Logat associated minerals. We have no way of even knowing. So this is a sector that really pains my heart in the way that logging has pained my heart for so long, Mr. Speaker. Let's get it right. You mean not like punishing investors? Genuine investors will see this as the way to do things. We do it when fair, they make a buck, they make profit. And the country must make a profit. Landowners must make a profit. It's what we're looking to do. And the environment must make a profit. The degradation here in stop for spoiling country, blowing me, Mr. Speaker. So I'm happy that the minister is looking into these things and this new policy by him addressing what is a very big gap for so many years. With those comments, I do wish to thank the minister.
Thank you, Honourable Leader. Let's move on to our next item of business.
Statement of government business for the week ending Friday, 24th October 2005. Further statement.
Thank you, Honourable Prime Minister.
Thank you, Mr. Speaker. Further statement of government business for the week ending Friday, 24th October 2025. Tuesday, 21st October 2025. Bills Committee of the Whole House. The Public Service Bill 2025. Committee of the Whole House comments and continues. Motion for adjournment. Wednesday, 22nd October 2025. Bills Committee of the Whole House. The Public Service Bill 2025. Committee of the Whole House continues. Motion of adjournment. Thursday, 23rd October 2025. Bills Committee of the Whole House. The Public Service Bill 2025. Committee of the Whole House continues and concludes. Bills, third reading. The Public Service Bill 2025. Motion of special adjournment by the Prime Minister that at its adjournment on Thursday, 23rd October 2025, Parliament shall adjourn to Monday, 24th November 2025. Motion of adjournment.
Thank you, Honourable Prime Minister. Let us again move on to our next item of business.
Bills, Committee states the Public Service Bill 2025.
Honourable members, the House will now resolve into the Committee of the Whole House to consider the Public Service Bill 2025. Thank you. We are now in the Committee of the Whole, and we will deal with the bill clause by clause. There are several proposed amendments to the bill, which was put on notice on Friday, 17th October 2025. And the rule governing proposed amendments to a bill in the Committee of the Whole House is as outlined in Order 52. And that is that the amendment will be proposed first, debated and voted on before the clause as amended will be proposed, debated and voted on. And we'll begin this morning's proceedings with, we'll start with clause 1. If any member wishes to comment on that clause, with the question. If there is none, I will put the question. The question is that, sorry, Honorable Leader of Opposition.
Yeah, thank you, Chairman. Just in terms of the title and perhaps our normal, everyday, colloquial reference, I was thinking this is nothing to do any change, but side law, we're meeting around, perhaps it could have been Civil Service Act. I thought word civil, perhaps the Minister could comment on that. Thank you.
Honorable Minister.
Thank you, Chairman. Let me give AG from Survey comment on that one. Thank you.
Thank you. Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, Leader of the Official Opposition, for that question. Unfortunately, because Constitution here put public service in a reference to the unless you may change in that reference, then we can do that, but it's the reference made in the Constitution. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Let me put the question again. The question is that clause 1 stand part of the bill. Those in favor, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 1, therefore, stands part of the bill. Clause 2, any comments on that clause before I put a question? Clause 2, Honorable Leader of Opposition.
Yeah, thank you, sir. Just for Minister Hemi clarifying which parts law bill you now, I would like for commencing when the way that clause 2, subclauses 1 and 2 are worded, supposes a graduated commencement. Thank you, sir.
Thank you. Honorable Minister.
Thank you, Chairman. The bill has set after it passed, but they were set for socializing around Honiara and other provinces for informed stakeholders the new Public Service Act, the regulation and the public service orders. All provisions of the Act are implemented at a date after socialization of the Act in Honiara and other provinces, except Part 6, Division 2, which is the classification. Part 6, Division 2 classification will be implemented after the new public service classification structure has been established. Thank you, Chairman.
Thank you, Honorable Minister. Honorable Leader of Opposition.
If Part 6 here, Division 2 here, Hemi commenced upfront with the rest of it, what now the impact of that? Why couldn't we commence everything at the same time? It's not as if we have multiple classifications in the old regime, so that 6 new classifications affect them now. So Minobaro understanding why the necessity to leave that for later. Thank you.
Thank you, Honorable Minister.
Thank you, Chairman. Yes, so as Mitaram, the new public service structure, I'm still work at understand. We need to complete that before commencing the full part long of the Act. Thank you.
Thank you, Honorable Leader of Opposition.
So what time now, roughly, you were thinking for finally commencing that whole party? Thank you.
Thank you, Chairman. The draft is already in place, and Bible please what time we should commence that one.
Thank you, Honorable Minister. There are no further questions. All right, Honorable Minister.
Thank you, Chairman. According to PS, we should and should be complete within 6 months. Thank you.
Thank you. Any further comments on clause 2? There is none. I will put a question. The question is that clause 2 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 2 therefore stands part of the bill. Clause 3. Does any member wish to comment on this clause before I put the question? Clause 3. Thank you. If there is none, let me put the question. The question is that clause 3 stand part of the bill. Those in favor, please say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 3 therefore stands part of the bill. Clause 4. Any comments on that clause before I put the question? And if there is none, I will put the question. The question is that clause 4 stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 4 therefore now stands part of the bill. Clause 5. Honourable members, there is an amendment proposed to this clause as appeared on provisional business paper number 63. And I ask the Minister to move the amendment. The Minister, please.
Thank you, Chairman. Sir, I move that clause 5 is amended by deleting shall prevail and the former shall, to the extent of the inconsistency, be invalid, and substituting prevails to the extent of the inconsistency.
Thank you, Honourable Minister.
Thank you, Chairman. This act, once this bill was passed, by prevail over other laws except the Constitution, only to the extent of the inconsistency. Existing act, like similar provision, are the Central Bank of Solomon Act 2012, Section 69(1), the SOE Act 2007, Section 25(2), and Pure Food Act 1996, Section 36, Biosecurity Act 2013, Section 7(2). Example, if the other law does not require merit appointment of a public officer, then the other law is inconsistent with Section 17 and 21 of this Public Service Act. Hence, only to the extent of inconsistency on the merit principle does this act can prevail. With regards to penalties or for offences or similar offences in this act, this act has the same weight as penalty for the same type of offence in other acts, including the Police Act 2013, Correctional Services Act 2007, and the Anti-Corruption Act 2018, and the Penal Code. Thank you, Chairman.
Thank you, Honourable Minister. Honourable Leader of Opposition.
Thank you, sir. Perhaps the Honourable Attorney General could help us in this matter. Law Bills Committee, especially police and prisons now, take issue with this particular clause 5 and the interface with their various legislations and the enabling provisions in those legislations for discipline within their services. And the recommendation of the Law Reform Commission was therefore to say, rather than have this blanket provision, was to be more specific and say, okay, if I'm inconsistent with these other legislations, or Police Act, or Prisons Act, or whatever, and sections also laws here, is for law now by prevail. That way there's a very specific and clear references to the laws, that rather than having them overall across all bodies of law. And so the examples given by the Minister, obviously, look also no any matter come before courts yet, therefore look law how outline kind general provision also. So perhaps the Attorney General could care to further clarify to the committee. Thank you.
Thank you, Honourable Leader. Any further comments on that proposed amendment? Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. In terms of structure, you mean you have the discipline ranks, and then you have the civil services, the public service here. So, with terms of the Police Act, it is sort of latched onto constitutional role of Commission of Police. So command and control everything, and so that's how the act is structured in a way that public service by him to follow run parallel Police Act, whatever public service in terms of just general application, public service. Sorry, it's a Police and Correctional Service Commission can take cognizance of that fact. However, in terms of you mean like applying public service rule or discipline right by whatever Police and Prison Service Commission, Police and Correctional Service Commission him tell him as the constitutional body which is responsible for them will prevail. And also too, when the Public Service Commission as the body look after public service decision will him. It's you may say him and prevail, so that's the structural act each one law will him come under law. Each employment you may say structural law. They have I'll start again. Police, the commissions under the Constitution, when they make their recommendations or regulations made thereunder, they have the same effect as an act of Parliament, because everyone comes from Constitution. So whenever they make their regulations or their decisions or whatever comes from what commissions, what a rank same level with them, what the act. So that's where you're looking hard for overlap, because whatever act him taleme, but him sort of come back more to follow commissions here, where to follow now, but have the last say in terms of how each what the employment scheme or employment cadre or him run. So in terms of police and correctional services, that commission has regulations what we have make him, and the Police Act and Correctional Services Act behind latch on with that one. Then whatever the authority will to follow will be what the Police and Correctional Service Act or what abide by. Whereas Public Service Bill or Act will always abide by what Public Service Commission decision him making, because they are the constitutional authority to follow different acts. So that's how they sit. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable Leader of Opposition.
Yeah, thank you, sir. So the long and short of it is, this will clause 5 by no affect them police and prisons. Okay.
Thank you, Honorable Attorney General.
Short answer, no more.
Thank you. Any further comments on that proposed amendment to clause 5? Honorable Leader of Opposition.
Much later, of course, I think towards the end, we're going to be dealing with the offences and penalties. Of course, there's in the notice of amendments proposed changes to the penalties law there. But in any case, so for example, where I've got offences here, same or some another legislation, but offences law here have lower compared to another legislation. Would clause 5 affect that inconsistency? Thank you.
Thank you. Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. No, it would not, because if me take an offense under this act, then this act will prevail. If it's under that act number him also a test for that offense would be you have to satisfy him under that act. Like for this one, if I say it's a misconduct, then misconduct under this one, no, by immediately. But if it's a misconduct in terms of you may say embezzlement, then it would be a criminal offense were like taken, then that would also apply. You can charge both at once, but then sometimes courts might say that I'll go for the higher one, I suppose, but then I'm up with courts too. What not courts are telling. But usually, long shots or no more affecting. Because it depends on the act you are trying to, you want to implement or you want to enforce.
Thank you, Honorable Attorney General. Any further comments on the proposed amendment to clause 5? If not, I will put the question, and the question is that clause 5 is amended by deleting, and I quote, shall prevail, and the former shall, to the extent of the inconsistency, be invalid, end of quote, and substituting, quote, prevails to the extent of the inconsistency, end of quote. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 5 therefore stands amended accordingly. And before I put a question in respect of clause 5, does any member wish to comment on that clause as amended? Thank you. If there is none, I'm going to put the question. The question is that clause 5 as amended stand part of the bill. All those in favor say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 5 as amended therefore stands part of the bill. Clause 6. Any comments on that clause? Sorry, there's a proposed amendment. There's an amendment proposed to this clause as appeared on business paper number 63. Again, I will ask the Minister to move the amendment. Minister, please.
Thank you, Chairman. So I move that in clause 6A, at the definition of accountable officer, substitute section 2 with section 2 of, and at the end of B, at the definition of special temporary employee, substitute means a person with means a political appointee, and C, at the definition unit, substitute ministry with ministry, and insert the following other definition of unit. In section 23(3) means the ability of public officer to understand the laws, processes governing the operations of public service system, and apply judgment experience and ethical principle and foresight in timely decision making that best serve the public interest. Thank you, Chairman. Yes, so the special temporary employee definition was amended with new definition, reads as follows. I mean that the political appointee who is not a public officer but an employee of the government, employed pursuant to Section 91 under an instrument of appointment to perform specified political tasks. Thank you.
Thank you, Honourable Minister. Does any member wish to comment on the proposed amendment before I put the question? Thank you, Honourable MP for Central Honiara.
Chairman, firstly, this will form law, Mike Lume for level. I don't know what happened. The second one is that I just couldn't follow the Minister of Public Service simply because there is no written core agenda to what he is suggesting. So, what shall we do?
Thank you, Honourable MP for Central Honiara. Have you consulted the business paper?
The first one is this one.
That I made reference to?
You look familiar too.
At least I can hear you.
Oh, okay, that's fine. Yeah. So I'll put it on.
All right, Honourable Leader of Opposition. You finish with a comment?
I'm asking that if there are papers that have been written out in a form of core agenda, so that we can follow the amendment that has been proposed by the Minister.
Okay. Thank you, Honourable Member. The proposed amendments, proposed amendment on the 17th, is Friday, are put on the notice paper. I hope you have able to access your notice paper to see those proposed amendments are actually written. Normally in your pigeonholes.
Yes, there is nothing on the, possibly at the pigeonhole, but normally it get distributed on the table, I think. Maybe you can just direct us where to go so that we will go to pigeonhole more. Yes.
Thank you. You'll visit your pigeonhole later, but Honourable Leader of Opposition.
Yeah, this one, no more. Business paper, notice of amendments, it's in the pigeonhole. That's where I got mine this morning. Oh, yellow one and provisional. There have been changes since the yellow one. And corrigenda would usually come at the end of this committee process, so for it's a small one. The issue we had yesterday, of course, there were matters in the corrigenda that rightly should be in the notice of amendments. So business paper would have all of that detail. I was just concerned as a point of order, no more, sir, that time Minister Hemi for Hansard record, Hemi read him come amendment, he must put in full stop, semicolon, what's the name as inside it? Because it's in some of these proposed changes, of course, under law legislation act to be passed last time, Attorney General can also do corrections, but just going forward to make sure we're, for completeness sake, that we're being accurate as we make law. Just comment on me no more long or get load this fella term wisdom in the original proposal and just stop law wisdom no more. But this is a much better, a little bit tighter, clearer articulation of what is meant by the term wisdom. Sometimes one of them wisdom lo you and out of foolishness to someone else. And something is foolishness to someone, it could be wisdom to someone else too. So when we're making law, we want to make sure that it is wisdom for everybody, so that he may guide in conduct in the civil service. And then law special temporary employee. You mean good, you mean make them clear. You mean minimum political appointees here also, who quite often are not temporary, and also quite often they're not special at all. They're anything but special. So I'm good for calling a spade a spade. Thank you, sir.
Thank you, Honourable Minister.
Yeah, thank you, Chairman. Mr. Gluder, what option did I ask him? Thank you.
Thank you, Honourable Minister. Honourable Chairman of the Bills and Legislation Committee.
Thank you, Chairman. Me looking more at the amendments. Me happy. Me like for talk. Thank you, Minister. Hardworking PS within major chambers. A lot of the issues where me follow partnership lo hem lo committee and me reflected law at the amendments. Another happy blow me, Mr. Chairman, is this is our law for the country, and time him to put him to commit lo hem lo that process law bills and legislation and bara helpful to us and important for going forward. Just a comment, Mr. Chairman.
Thank you, Honourable Chair of Bills and Legislation Committee. Any further comments on that clause? Amended clause. There's, sorry. Oh, no further comments on that clause as amended. If that's the case, I'm now going to put the question. And before I put the question, I think there are no members who wish to comment on the clause. I will put the question. The question is that in clause 6, A, at the definition of, and I quote, accountable officer, end of quote, substitute section 2, with section 2 of the end of quote, and at the definition of, to quote, special temporary employee, substitute means a person means a political appointee. And C, at the definition, unit, substitute ministry with ministry, and insert the following after the definition of unit. And I quote, inverted comma, wisdom, end of quote. In section 23, 3 means the ability of a public officer to understand the laws and processes governing the operations of the public service system and apply judgment, experience, ethical principles, and foresight in timely decision-making that best serves the public interest. All those in favor say aye. Thank you.
Just one comment.
Honorable Leader.
Thank you. Sorry for dragging me on that. Again, reading below you must accurate to same point me raising with the minister, make him record him straight. But in wisdom, this new definition of wisdom here, the idea of trusteeship really should be here. Wisdom acknowledging living under the concept of trusteeship is critical in determining whether one has been wise in their conduct of a public office. And I'm wondering whether we could maybe further amend that definition by adding trusteeship somewhere or there. That I think would add value. Thank you, sir.
Thank you. Honorable Minister.
But that's committee for maybe clarifying them. Thank you.
Further clarify the question, Honorable Leader. The Minister wants you to repeat.
Me ask him, AG, for clarifying them.
Oh, sorry.
Thank you.
Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question, comment, or suggestion. It'd be quite difficult for me and Adam in now because public service, this one I'm applying law officer. The officer might start from the highest ranking to the cleaner, for example. So, but if you put him with a cleaner by him, counting trusteeship, that kind of thing. So, maybe if in terms of the levels of decision making, that could be we could do that. But for you, with general application for across the board, meeting him, it wouldn't be appropriate at this level. Maybe if you miss for it's where garem or decision making powers attached to them. It's because when you make a decision, that's when you exercise trusteeship decision to. Whereas what time clean up, we come to clean up no more there. Or public officer too, yeah. But how do we? You time what that on, but say, hey, I'm not in a position for making fiduciary duty. Mr. Trusteeship, then fiduciary duties come in, and it be by attaching goal at certain positions in government. So, and also, this is just a principle. No more how many reading for you. You, in terms of interpreting, no, it's not something that go to some significant aspect of a public service bill, but more of a principle that you may add in one Lokata officers the public service. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable Leader of Opposition.
Thank you, sir. If we take that line of argument, sir, and you may say, oh, cleaner, no need for, no any real fiduciary responsibility, Lohem. Well, if we look at other parts of that definition, by same to understand laws, well, cleaner no really need for understanding laws. processes governing operations for public service systems, apply judgment, experience, look cleaning, I'm good, ethical principles and foresight in cleaning. So if we apply that same rationale across, by this, general enough, but the principle of trusteeship is so core, is such an important critical element that even a cleaner is a trustee. Take a toilet paper lo inside the bathroom, you run away waiting, or take detergent, you run away waiting, or you have a fiduciary duty. You're a trustee of what is entrusted to you in your work, whether high or low. But to me, that's the core. Trusteeship is part of the core to making sure we see wisdom being exercised. Thank you, sir.
Honourable Minister.
Thank you, Chairman. The usable trustee, let me address law section 16 and 17 of the bill. So we'll come to that later. Thank you.
Thank you. Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for also that comment. If we go to 23, clause 23, it's just basically those values that we are putting in here. So would we want to tone it down to become a trusteeship, to become a value, or is it something that's ranked higher than that? It's more than. Just my point no more is that having it as a trustee, putting on just like a value that you may come together, you may see that you may value, is not giving the importance that a trusteeship should be placed in the public service. So I know the point. Thank you, Mr. Chair.
Thank you, Honourable Leader.
Thank you. I accept that. But, the more places trusteeship appears, the better. Because it does seem to be a missing component, a critical component. It's like saying, the fear of the Lord is the beginning of wisdom. So we could just say that here, ultimate definition, to say the fear of the Lord is the beginning of wisdom. When you exercise, of course, in our private lives, of course, but when you're exercising public office and you're exercising it with full cognizance of God is watching you, what you're doing, you make sure you do right, that's wisdom. So trusteeship is kind of similar. It's both a value and an essential element of exercising wisdom. I suppose that's all I'm saying. But me accept the explanation by Minister and the Attorney General that by the time we come for amendment bill later on, that the trusteeship will then be brought in. Thank you, sir.
Thank you, Honourable Minister.
Yeah, thank you, Chairman. Yeah, so the principle of trusteeship have now formed the basis of the code of conduct and every other thing as you look along Part 4 law bill. So the trusteeship definition there, the trusteeship is an overarching principle that the public service by him must comply with him. Thank you, sir.
Thank you, Honourable Minister. Honourable MP for East Arare.
Thank you, Chair. Just on the definition of wisdom that's in here, I also not too sure about this sort of defining what wisdom means in the context of public service. But then in the second line there, when it talks about process governing the operations of, and this is the phrasing, the public service systems. What is the public service systems? And Lucas might need him, not a definition by itself to describe what is the public service systems. I mean, it seems to describe something that we should know about. I just wanted to ask that question. What is the public service systems? Thank you.
Thank you, Honourable Attorney General, Honourable Minister. The definition of public service system, please.
Thank you, Mr. Chairman. Thank you, MP, for East Arare for that my question, I would think the public service systems would be recruitment, appointments, what systems are there, and that's the reference to it. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Bola MP for East Arare.
Thank you, Attorney General. Thank you, Chair. So it does mean that it might need its own definition in terms of what now, for clear no more. What does it involve, public service systems? And if that's the case, then perhaps imi autim daya no more of public service systems no more. I mean, just the word "da" there seems to imply that this is some term of, definition or defined term. Maybe it'll help if we take out just that and just go straight to public service systems with the explanation that's given by the Attorney General, and then at least the intention is clear and it's in Hansard. Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for East Arare, for that question. I can look into that. There are instructions for that at the moment, but if I'll have a look into it, if that warrants removal, misagreement under legislation actor, Attorney General can do that removal at a later stage. But I'll definitely look into that. Thank you, Mr. Chair.
Thank you, Honorable Leader of Opposition.
Really, the Attorney General can do that removal after the fact? Law here, also Member Blow East Arare said it's referring to a definite, the use of the definite article "the." So it would seem to be like, once you pass him, it's the intention of Parliament. Removal or something, or if there's a typo or it's a small something, no more. But removal of something where I'm intentional, deliberate, also might be a little bit more problematic, and better that you may do him law here or committee. That would be my view, sir.
Your view, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. It could be just a mistake, that the word "da" was included. For example, Solomon Islands, some Takasa mistakenly put in "da" Solomon Islands, but that's not a legal reference to it. So if the legal reference to public service is excluding "da," then it's by him, you may say it's a mistake. No. But if inside law constitution there's a reference to "the public service," then that's by him stop. But if in the constitution the reference is to public service, no more public service, then it might be just a drafting mistake. Then that will allow the Attorney General to make that correction at a later stage. But even though we're still in committee, as we go on, in 23 yet 2 years, so we can explore that as we go on. So clause 23, when it comes back, it's a reference to that definition. Then we can also revisit that law. Thank you, Mr.
Thank you, Honorable Attorney General.
Sir, thank you. That was helpful. So in other words, what the Honorable Attorney General is saying, we could split it, just those 4 terms, so that the public service is different from the reference to systems. So the object is the public service. And the subject now with systems here. So if you were to turn it around to make it clear, would be the operations of the systems of the public service, is what the Attorney General is saying. It could be that that's the reading of it if Constitution hemi affirm that the public service na hemi is the formal title of him. But good, the explanation, we could come back to this and sort it out if take them on notice and look at him. Thank you, sir.
Thank you, Honorable Attorney General. What about proposing a corrigenda before the third reading? Is that possible? This other corrigenda by amending that. Okay.
Thank you, Mr. Chairman. Yes, that is also possible, one avenue to do.
Then, therefore, we can dispose of this with the intention that when we come back for the third reading, the correct data is added and it's amended to this. Is that correct? Thank you.
Chairman,
Honorable
just coming back to this point, coming back to this point of where Dualea Lulukulohemi, the public service system. I thought that is well defined, Lord, Chapter 13 of the Constitution. That whole system here, all bundled inside law, Chapter 13 of the Constitution. And in the way that I see what is being featured in this bill, seems to capture the whole lot inside too. So that's possibly why they are referring to it, the public service. I'm not sure. It will man English speaker straighten gamna patia. Thank you.
Any comments on that observation by the MP for Central Horniara, Attorney General?
Thank you, Mr. Chairman. Just for clarifying, the references in the Constitution, for example, Section 15, subsection 6, the reference that's made into the line is to be required of any person who is appointed to any office in the public service. So the da have come from Constitution and land. So I think that's where the definition has pulled out. So I would say that by me leaving that da is what the Constitution has placed before it. So thank you, Mr. Chair.
Thank you, Honorable Attorney General. Coming back to the point earlier raised, Honorable MP for Small Malaita.
Thank you, Mr. Chairman. So, in line with the proposal by the member for Central Horniara and then affirmed by the Attorney General, I was just wondering whether this was a Korea agenda here, and we put them out system here, word here. Thank you.
It's another option to send the reading will therefore be, you retain the governing operations of the public service, that you delete the system. The system is that that's already governed under those provisions explained by the Attorney General. So that's another window the committee may wish to consider in the core agenda. Either delete the or the system.
Mr. Chairman, in line with them, Ogata Dr. Megam Kami, I think you miss retain the word "the," and then out this word "systems." Putum correct gender. Minosa with them satisfied, Mr. Arare. Thank you.
Thank you. Sorry, Honorable MP for East Arare.
Thank you very much, Chair. And, Small Malaita, I'm always satisfied, Mr. Aremo. But on this one, I think that's how we can deal with it. So the public service, and then we get rid of the system, and I think that would be very clear in terms of what it is we're talking about. Thank you.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, MP for Small Malaita and MP for East Arare for that suggestion and comments. I have no issue with removal of systems because the line we have started to say wisdom in Section 23, subsection 3 means the ability of a public officer to understand the laws and processes governing the operations of public service. So if system out, then still refer processes law there. So I don't have an issue with that. It still can mean the same thing.
Thank you, Honorable Attorney General. So the proposal here is that, excuse me, we still vote on the proposed amendment, but with the intention that we omit the reference to the system, and through a core agenda, we'll bring it back and put the full sentence without the reference to the system. The behind remain the same as it is. Acceptable? Okay, the issue is, yeah, sorry, the Minister, you have the verdict.
No, thank you, Chairman. Let's do that for you to make them clear.
Thank you, Honourable Minister. And the details, again, of course, Public Service and the Attorney General will work on the core agenda, how it's going to be captured in the final voting there before the third reading. Okay? So the call here, I will still ask the committee for the proposed amendment, taking into account the proposals in regard to references to the system. Then we vote on that, the committee votes on that, and then we'll correct it accordingly before the third reading. So on that note, I will now put the question. The question is that clause 6, clause 5. Clause 6 as amended, stand part of the bill. Those in favor, say aye. Aye. Those against say no. I think the ayes have it.
Point of order, sir. In clause 6 as amended, yeah, we're still dealing with the amendment. So you mean it for vote or amendment ever stand?
Sorry.
Then you may just go to clause 6 as amended.
Sorry, I was jumping the gun, but again, let me put the question. The question is that this is clause 6, right? And I have to read the whole text here. Clause 6A, the definition of accountable officer, inverted commas, accountable officer, close inverted commas.
Order, Speaker. Can I just interrupt you? Me, like come back more on the amendment about wisdom here. A particular line towards the end, which says timely decision making that best serve the public interest here. So, Miluluklo here, there is no definition of the public interest too. Can we just apply number as public interest number or same more? What is that public interest here? Thank you, sir.
Okay, the...
Sorry. I'll ask you, Minister Nomor, what is that? The public interest here.
Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, MP, for Central Honiara for that question or suggestion. The public interest phrase used in the Constitution too, yeah. So why it's kept along in here. So you have the public interest, the public service, the Public Service Commission, Judicial Legal Service Commission. Those are phrases used in the Constitution. So when we apply them, we just take them out of the reference name. So it's consistent with what Constitution make them come. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General, Honourable MP for
Thank you, sir.
Central Honiara.
Yes. I think that is well recognized that there are phrases in the Constitution that in particular where it relates to those particular institutions that are stated in the Constitution. But, it's like when you're opening it up in the way that it is being expressed over there, just want to suggest, Nama, that in the same way that we apply to the earlier or the second line here on the public service system, that we have removed it. Why can't we just say, making the best service or making the best that serves the public no more? It serves the public. Then you full stop there now. Rather than you may go for defining for not interested. So small mala, you help out a little bit longer. No. Yeah. Something was in me. Yeah, say.
Thank you, Honorable MP for Central Honiara. Any comments on that thinking? Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for Central Honiara. The courts have been defining the public interest over time, issuing judgments. So when we drafting laws, we look at statute law and common law. So when we don't, sometimes Parliament tries to shy away from defining actually set definition law, public interest. So you won't see a number, the public interest defined in statutes. They usually leave it to the courts to interpret what the public interest is in accordance with what the today meaning. So not for breathing life, lot of terms here. So that's why we tend to use the same phrases in our law. So when it comes for interpretation, we go back to our common law for helping you in interpreting what now definitions, especially in terms of public interest. Because public interest 10 years ago may not be the public interest today, and may not be what is 10 years down the track. So that's why we leave it to the courts to interpret it in their wisdom. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable MP for Small Malaita.
Mr. Chairman, no, this one me suggesting no more, making me go forward. Yeah? Me look at this one. No, me try to understand them. Why now this whole drafting is this way? Then me thinking, no, Mr. Chairman, this is to distinguish between private interest and public interest, or public interest as opposed to private or also private interest. So if you may put them also in public here, meaning everyone and private employees level. I'm now teaching below me no more, so also meeting him. If what the definitions and what the iterations where Attorney General have referred to, law courts and other legislations may be, I'm all right no more. I'm not teaching below.
Thank you. So what is suggested here is that the use of the public interest in the context of this law appropriately represents the way that, especially including what is in the what the law stands for, is to do with public interest. Sorry for the confusion, Honorable Attorney General. I'm asking his indulgence. Okay.
I want to just cut it short. No more, instead of drawing you into the confusion that I myself have raised. Now, small Malahem confusion me a little bit go more with this drawing in the private and the public interest. Of course, you cannot find him anything in any judicial decision is private interest or paramount. Nothing has to be public interest. But the service law, public service, is for the public here. I no more why we come to that point. But when it comes to Yumi specifically make reference to public interest, then I think this is where it calls for Yumi for try for defining what is it, Hamilton. But say, I'm satisfied with what now the AG has explained so far. I think let us move on. Leave it as public interest. Thank you, sir.
Thank you. We were already going to move. Okay. Honorable MP for RR.
Thank you. I think it's good that we're having this discussion, and it's in hindsight, because the courts will be looking into these things if they need to. So I think this is helpful in terms of what the intention is here. I think as Attorney General Hamtalemia, public interest is quite a term of particular endearment under the jurisdiction, jurisprudence, Blue Emil or Solomon Islands, and how it's developed. It comes down to the issue of who has standing in that court case here, in terms of Garam standing for protect them, no public interest. And courts have ruled that sometimes some Garam, the Attorney General Garam, public interest. So these are serious issues, Mr. Speaker, sir, but it's quite defined already in the courts. So the idea that the suggestion by Central Honiara for a full stop number after public no full stop, you leave him out interested, and then that should take care of the concerns here, so that it's clear. The idea is to make it straight and clear in terms of our lawmaking, so that yumi no pushun kamwa that fala term phrase public interest inside molo lo good bill where Minister Hantakem Kamemo that has certain already connections to jurisprudence development in our country. When it comes to issues that we know that the courts, as AG correctly says, it's already made some pronouncements on it, I think it's good that we keep the courts jurisprudence, because it might be developing it in terms of those kind of space. So the idea is we just support them no more. The idea, if we can really seriously think about putting full stop no more after public, and then we leave out this public interest phrasing, which might cause some headache more to try and define it. If you look at the Constitution, there is no definition on public interest. It's implied. It's implied under the freedoms, individual freedoms it's given there, interest of a public or health or something else. But in terms of public interest itself as a phrasing, you will not find it, although it is implied there in itself. So I think I just want to make a last-ditch kind of thinking to the good minister for you me putum full stop after public. And then I think that whole thing is still captured in terms of what it is we're trying to do in making this law. Thank you, Chair.
Thank you. Honorable Attorney General, Honorable wish to comment on the observation by the MP for his Arare.
Thank you, Mr. Chairman. My suggestion would be, as you already told me, we keep it more if we come to another problem down the road, then you may try for come. But at the moment, as it is now, it's just tagged to clause 23 normal, and it just says normal that clause 23. There are 9 public service values. Then I'm outlining. Then additional one, and I'm saying you have to have wisdom. Mr. Trana to wisdom. So, but it's just a value. I don't think it's something that will change the definition of or how public service, or you may implement him after, or you may also interpret him in a legal way. It's a value that is placed in there, and it's not something that you may say him by deterring. It's read in a positive way. That's what I'm just trying to say, that when you try to make him here, but later maybe if by you look him start for bedding him implementation, then we could come back and amend it. But as it is now, I'm just cautious about how the reference to it in the Constitution, you may out him, it might time come for interpreting what might say, oh, just because of the public law there, it widens up the definition or the scope. Whereas when interest, public interest, by narrowing down, as courts have been doing, removal of interest, my view, would broaden him up, then just make him more application go wider as it is. And just by fiduciary duties as trusteeship would be linked to a beneficial interest in any event. So that's why I would suggest we keep it as it is, and we will come back to it if there's any issue in the future. Thank you, Mr. Chair.
Thank you, Honorable Attorney General. Honorable Leader of Opposition.
Yeah, thank you, sir. Just in terms of the point raised by Member Below East Arare, with regards to standing before the courts or for public interest. So hemi say on some matters, court hemi read him narrowly lo pugarem standing and Attorney General no more. In other matters, I think you, me, as members of Parliament, we could, like constitutional issues and all same. But that issue, in terms of this definition, by him no really bar him anyone, that if there was a justiciable matter, once you keep him in public interest here, that full term, matter whereby, or by only Attorney General no more, take him up any matter of public interest or same. Thank you.
Thank you, Honorable AG.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. For answer, I'll say that I am working on the Attorney General's Act, with the DPP's Act, Public Service Act, with the Ministry of Justice. So in that, it will clearly put them out now, the roles of public interest also, and how public others can apply it to the Attorney General. For Attorney General, give fiat blame. In law, it's called a fiat. The Attorney General is the guardian of public interest. But if anyone like apply for him, apply come Attorney General for him, give him, and there are rules you apply on that one too. Standing in alternative. So in any event, if a member of Parliament would like to apply to for public interest standing case, make him application, Attorney General him give him for that reason. So we're trying to come to Parliament for debating, but in other jurisdictions, that's how it's dealt with. Public interest, Attorney General him give him by way of fiat, look at individuals who would like to enforce that public interest. Thank you.
Thank you, Honorable Attorney General. Any further comments on the clause before I put the question on the amendment? If there is none, I'm now going to put propose the consideration by the committee, and I will put a question to clause 6 as amended. And the clause 6 is proposed for the amendment, and I read again. A, at the definition of accountable officer, in inverted commas, substitute section 2 of the with section 2 of the close inverted commas, and at the definition of special temporary employee, substitute inverted commas means a person, close comma, which means a political appointee, and C, at the definition of unit, substitute ministry with ministry, and insert the following after the definition of unit. After the definition of unit, it means that we add wisdom in section 23.3, means the ability of a public officer to understand the laws and processes governing the operations of the public service systems and apply judgment, experience, ethical principles, and foresight in timely decision-making that best serves the public interest, close inverted commas. All those in favor, say aye. Those against, say no. I think the ayes have it. The ayes have it. Clause 6, therefore, stands amended accordingly. And before I put the question in respect of clause 6, does any member wish to comment on that clause as amended? Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Just long definition of recognized association means an employee association recognized by the PS under Section 105. And lo there, hemi recognizing both those that are registered under the Trade Unions Act and then associations that are registered under Law Charitable Trusts Act. When we come to it, we'll deal with it there. But I'm just wondering whether, is that a reference when start come law constitution? This for term association here, whether any for trade relations. matters. Thank you.
Thank you. Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. In terms of association, I think the freedom of association under constitutional fundamental rights blaming, recognizing the right for anyone to associate with him. Well, let me just find the word. It's section 13 of the Constitution, where him say you have to you must respect the right for someone to freely associate, including trade unions, political associations, or same. So with that, form of Trade Unions Act, Political Parties Association Act. That's why I think recognition, what the recognized association is put in there is to recognize that fundamental right to associate. But whichever association must be by way of law. And so recognized association is by way of association registered under a law. So that's when you have lawful standing and lawful or be a legal entity as well. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Honorable Leader.
Yeah, thank you, sir. I mean, it's a policy choice under Law 105, and when we come to it, we'll look at it again. But, taking the Attorney General's example of political, associations in the form of political parties, well, the Political Parties Integrity Act and make them clear that an independent cannot be part of government, for example. Only political parties can form government. So there is a clear Parliament taking a clear intention, law that matter, and as we know, the Charitable Trusts Act, really no meant at all to provide the kind of governance where trade relations can be conducted. So in terms, from a policy standpoint, it would be better that all trade relations are conducted under the Trade Unions Act, so about clear. So any associations, you're free to associate, but if you're seeking recognition, you must register under the Trade Unions Act. That would be the policy, the preferable policy position. If that is the preferable policy position, then of course, then this definition and law, section 105 would need to be amended as well to reflect that. I would contend, Mr. Chairman, that would be the ideal. One gate, that gate is Trade Unions Act. Thank you, sir.
Thank you, Honorable Leader. Any comments on that observation with Honorable Attorney General?
Thank you, Mr. Chairman. I just didn't get the last part where, Leader, the last recommendation or suggestion you made. If that can be repeated. Thank you, Mr. Chairman.
Thank you, Honorable Leader.
I was just saying, if that was the policy position to pursue, and I'm recommending that we do pursue it, it's the better. The ideal situation is to just have one gate for recognition of associations is through the Trade Unions Act, so that we don't have the current situation where some are registered under the Trade Unions Act and some are just associations freely associating registered under the Charitable Trusts Act. So I was suggesting that perhaps, again, by the time you become section or clause 105, that issue by him come up. So if you may amend them there, by him affect him come now, this fella definition here. Well, it won't need to be there at all now. We'd have to delete it in its entirety. Thank you.
Thank you, Honourable Leader. Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, Leader of the Official Opposition, for that question and suggestion. I'll just speak on what the current status quo is. Currently, we have the Trade Unions Act, the Trade Disputes Act, and the Essential Services Act, and those complement each other. For Essential Services Act, you cannot go on strike or anything unless you are part of a trade union where for that purpose you. So for example, recently we had nurses, and nurses are part of the Essential Services Act. So before you issue that a strike, there are a number of things where you must comply with him. One is you issue notice, you must sign himself too. Then you give him a trade union. Then it's a trade union, he must submit him come, follow him to what. Then the strike you like for doing must be in relation to an employment condition or service condition. Or say you cannot go outside of that act too. So, and only that can enable you to take industrial action. So as it is, although I would say our laws are being reviewed now and old, but those mechanisms that we still have now in terms of industrial action. And once you go to strike, then you go to trade disputes panel. Once the issue is made and a referral is made to the trade disputes panel, every strike ceases. So I'm not current status quo and what not laws blame me. Thank you, Mr. Chair.
Thank you, Honourable Leader of Opposition.
Yeah, that seems to affirm my arguments that him better that all industrial associations are coming through the Trade Unions Act, and then of course comply with the Essential Services Act and so forth, so that we don't have a situation where a charitable organization is on strike because they're registered under the Charitable Trusts Act. So it's a nice evolution. It's the next step up. So really, it's a policy choice here. If Minister Hemi accepts that that's the more preferable policy position, then we should do that. I mean, no good that some people are registered under the Charitable Trust Act, and therefore they are charities, and charities going on strike, and all maybe self-defeating. So, thank you.
Thank you. Noted, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that comment. Currently, once you registered under charitable trust, but you cannot go on strike, or you perform a number of activities because the charitable trusts which clearly what purposes where you have to pursue. One is religion, one is education, another one health and disability. I'm not current one blue me. So when it comes, trade union is not a charitable purpose. So you can't have a charitable trade union registered as a charitable purpose, because it's not a charitable purpose, and the purpose as defined under charitable trust is clear. Also too, politics fall under political association, fall under charitable trust too. A number of associations were like try for associate, say for political or rejecting because of that purpose. It's not a purpose under the Act as defined for a charitable purpose or as designated by the Minister. Thank you, Mr.
Thank you, Honourable Attorney General. Honourable Leader of Opposition.
That seems to further affirm my argument that I think clear one momona you may should out him. You may not recognize him any association more. Must register properly with him Trade Unions Act. Now make him you me government dealing with industrial relations associations. I'm just clear cut no under one piece of legislation, and any reform, any changes to that legislation will affect them. All those who are registered there as opposed to having some fellow registered but are misusing Charitable Trust Act. Thank you, sir. Perhaps the Minister could.
Thank you, Honourable Minister.
Thank you, Chairman. Both union and association have been recognized under the Trade Union Act, and the definition will be inside of Trade Union Act. Thank you.
Thank you, Honourable Minister. Honourable Leader.
So perhaps the Honourable Attorney General could care to clarify that statement a little bit more in terms of Trade Union Act. I'm recognizing, is it just a matter of the terms? Trade union term used, law and or association could be used, but they are both registered under, the point is they have to be registered under the Trade Disputes Act, also the Trade Unions Act, Mekemhemi recognition and governance and all those other issues are easily dealt with. Thank you.
Clarification, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. I think 103 could also lend an interpretation, I may say, assistance to me. 103, clause 103, employee association means a trade union within the meaning of Section 2 of the Trade Unions Act. Then I'm coming to say, or other association which employees, members, the purpose of which include representing and protecting the interest of its members.
Thank you, Honourable Attorney General. Honourable Leader.
I'm not there now issue Blomia, that will be or any other association here. What the Minister is saying here, any other association as defined by the Trade Union Act is what the Minister is saying. So if recognition is under the Trade Unions Act, then I have no issue there. But if it's that association is under some other legislation, then we should tidy it up. Thank you.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that insight on this one. Take your point. Maybe by me deal with him as we get to that. Let me get instructions on this. And if I get your point, the point is you would like to limit it and strictly put on that you cannot come any other way but trade unions. No, you have to be registered as trade unions before you can constitute a trade or industrial action. So I get your point. Let me take more instructions on this, and maybe we'll deal with it. I may get to that part. Thank you.
Thank you. Honourable MP for East Are.
Thank you, Chair. So in terms of 6, we've agreed on the amendments already. The definition of wisdom was what we were talking about in terms of the public interest aspect of it. Although, just to point out more that we're not even talking about individual interests. We know that when you serve the public, it's not always about public interest. So I just wanted to note there that that's missing in this definition of wisdom. So I'm thinking that the implied thing is that when you do with individuals, you apply foolishness. Because I'm not covered under the wisdom definition we just passed. Just something for us to be mindful of. It would have been good put a full stop by, but now that it's there, you automatically not looking at individual interest too, because public service also serves individual interests, not necessarily just public. Thank you.
Thank you, Honourable MP for East Are.
Hey, this one has something more spanner in the works more. This one. Would that be an issue? Obviously, you're going to pay for a license, or you follow private interest. You go, man. If I would say, hey, no more private interest, that one, I'm only serving public interest. Of course, the bigger public interest is the economy has to function, city has to be cleaned up. If our town council wake up one day, and what kind of same, but would that be an issue? This issue raised by Member Blue East Arar?
Thank you, Honourable. Honourable MP for East Arar, can you repeat again your observation or statement, the comments that you made? Can you repeat yourself, please?
Thank you. Thank you. Thank you, Chair. I think the point I was just making, Noma, is that I accept the fact that we did a definition for wisdom here, and in that definition we only talked about public interest, and we have left out private or individual interests. We know that public service also serves private interests. When you go and get license for your vehicle, it's for your own vehicle. It's not for the whole town to come in. That's a public transportation one. So the idea is that at least for the definition of the wisdom that we have agreed on, we have left out individual or private interests. So my point here is that when we apply wisdom, we apply it just for public interest. But when it comes to individual ones, maybe it's not covered by our definition of wisdom. So maybe we do unwise decisions when it comes to private individual. My point is that, you know, if we had put the full stop in public, I think it also covers individual as well as public, broader. Because I think public interest has a certain definition. You're talking about the public welfare, like that. But not all services provided by a public service is for public welfare. Many of the services, as we all know, is for individual, private citizens. So it's just to note that the definition we passed with regards to wisdom doesn't include individuals.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman, and thank you, MP for East Ararai, for that insight and also comment suggestions. As opposed to private individuals who come time give license, those are welcome trusteeship issue. Leader of the official opposition regime, those are covered under various specific legislations where him give you criteria for apply everything. So the whole Public Service Act or bill is basically how conduct. You may say conduct the public service. So come in time you work along, but time you go into your specific niche areas, there are also legislations that are applied to when you issue a license or when you make a decision or when you revoke a license or same. So the whole public interest, you say wisdom, you put them come for public interest. The value is what value is not you put them inside the public service as a whole, as opposed to what no value. Sometimes you work at challenge and you make a decision, which that's covered from in another legislation context. Now, if we go that one, then you're opposed to that private individual claiming a private right. Now, whatever happens after, there's a remedial kind of aspect to him coming in. Whereas this one, there's no remedial thing we have attached to it. It's just us saying that this is the value you put into it. Whereas in a licensed party, you put him, fiduciary duty come in, him got him whip him behind. You know, what now, but you carry heavy him. Make him license. If you do wrong decision, what now, but you courts law there for straighten you. Whereas this one, him value, you put him go, it's value what? The public interest as a whole. That's why I'm there. Maybe the policy intention him wrong, but that's from a legal perspective how we look him. Thank you, Mr. Chairman.
Thank you, Honourable Attorney General. There are no further comments or observations. Honourable MP for Central Honiara.
Chairman, this will recognize the association and sort of move away from point very well presented by East Rare Loyamia. Shall I recognize association? You and I have been involved in the association of CPU, CPU Union before. I think the process that we took at that time was registering association under the charitable and then getting the recognition under the Trade Union Act. So I think it's a two process. You do it lawyer and then after, then you do the registration. I think that's where that recognition may come inside. Same with the credit union too, that we started. You incorporate a company and then have it registered under the Credit Union Act. So that's where you get that recognition. So the definition is what Minister Mtalem, I think I'm probably right in that sense, because you have to come through that two process of having to establish the entity where those membership will be covered under, and then registered under the appropriate. So one of the provision of constitution that we have always been reminded of is Section 13 here, law constitution, where Attorney General refer with the rights of individual too, where he chose to, he's at liberty to make a choice which association wanted to register under, and defining too, you know, the trade union, the political party under that Section 13 law constitution. So that's where that point that I raised about the public interest here and coming in the way that we define wisdom here. Not only every public interest, no more you mean. Yeah, so public interest is, to me, it's a composition of almost everything. Yeah? Individual interest, goal, or community, and all of that. So, say now I know that I'm the only one when me break him too. Something the microphone blow me here, but I hope that you can come and fix it later. So it's the composition of all of that. Him now and me, those public interests there. So why don't you me just stop normal of public here, emotion in that wisdom that we are serving the public, yeah. And all of that interest and covered no more. If you look low Section 13, even right at the end, say too, of his interest, para personal interest here, Constitution and protect him too here. And this particular recognition of the union would, in a way, protect him, that personal interest below that guy, to be part of an association, say. If I can just rekindle him back more to the whole argument about you may define him as wisdom. And where we are saying that, you know, instead for you may go and then say it's a public interest, let's stop at the public here no more. Because there are all interests inside law there, say another confusion more, I think me give him come here, but that's how some of us sort of, you know, brought this issue, you know, and I think it's a good thing for you for discussion, lawyer. Section 13 law constitution. Thank you.
Thank you, Honorable Attorney General. Any comments on that observation?
Thank you, Mr. Chairman. Thank you, MP, for Senator Honera for that suggestion. Only difficulty I have with that is most of our laws, where you look in that him never stop the public here. You will see the scheme of the legislative scheme in our laws. You will see public interest, public emergency, public safety, public health, public. So there's never a part in our laws where you see just the public is used. So that begs, why do we have this additional word? Because the public, as it is, him broad. And it poses a difficulty in terms of when you try for interpreting that term. So when you narrow it down to public interest, welfare, public safety, health, public safety, health, order, public order, what kind of thing. So you'll see that's the scheme of term that is run through most of our legislations. Might be wrong, I haven't seen anywhere public on its own. So the interpretations from that by Alomi would be quite difficult. So by having a public interest, you are saying to the Ayumi law public service values that you have to embody when you work for that is to ensure public interest can prevail, which is, as I think MP for East Area him telling today is basically welfare law, public Yes, so it's basically in relation to the overarching welfare, right, and good of, you may say, the public. So that's why we have each word tagged to the public and not the public on its own. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Honorable Leader of Opposition.
Yeah, thank you, sir. Like no more longer this definition of special temporary employees here. You may amend them first time, but the term right law in there to perform specified political tasks. What would be considered political tasks and what are not political tasks, I suppose? Thank you.
Honorable Attorney General.
Thank you, Mr. Chairman, and thank you, Leader of the Official Opposition. I think that it's just saying that pursuant to a contract of employment, so that your task would be based on once you're appointed as a, let's say, for example, policy secretary, your task would be to ensure that the policy government is carried out in its ministry. So that's a political directive from the political government. So, but by him outlined inside law contract of employment, or terms of reference, or key results areas, which him not political task by outlining. Thank you, Mr. Chairman.
Position.
Yeah, thank you, sir. So, I mean, ministers routinely give political directives, for example, to members of the ministry, to our public officers. So, similar directions, no? But I suppose those are not in the instruments of appointment, so that makes it not political. Is that the distinction?
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. Law, the scheme of law, constitution, you have the minister as the head of law. The minister has this constitutional duty of giving special directives. It's not a political directive, it's called a special general directives, and not terms we have used inside law, what are laws. So that has a different effect as opposed to a political something. It's basically rank him not ministers. So the ministers are discharging a duty by way of constitutional provision, whereas the political special temporary employees are part of a contractual arrangement or agreement of service, but indicate for him under Public Service Act. Thank you, Mr.
Thank you, Honorable Attorney General.
I'm anticipating, someday in the future, Mr. Chairman, that every member of Parliament will have, an office. We have offices now, but staff which would be appointed under kind scheme also. Right now, Prime Minister's office no more, and then opposition office and independent office. But someday in the future, every member of parliament ought to have officers assisting them, and those officers would be political appointees other than constituency office. So I'm not thinking around whether this would then capture it, or this is merely codifying current practice where just for three fellow officers. Thank you, sir.
Thank you. Honorable Attorney General. Can you repeat your question, or Honorable Minister?
Yeah, it's a policy issue.
A policy issue. Okay.
Thank you, Chairman. So this one, imi codify no current practice naman. Yeah, so imi put him inside the bill. So it's the current practice, imi just codify and be part of the bill.
Thank you, Honorable Minister. Honorable MP for Central Honiara.
Thank you, Chairman. So the employment that is referred to along other parts of the body law, ministry, and then this one suddenly MC government. Would that be correct? Because they are also in the civil list here, yeah? Or are they contracted? These positions are no exist in the civil list. They are basically a creation of a political government or something. Yeah? So, in that case, yeah, do you think that we should? Is it right for me to label it as government, or should it be a department or the office of? Because every place everywhere in the Belia, you may always refer to the employment under the ministry as a unit, yeah? This one I am alone, is government. So, what is the, what may be the intention of why we put it like that? Is it off the civil list, that's why it is a government, or is it, it is not? When I say it's off the civil list, means that it is not in the establishment register. That's why we say it's the government. Is that the distinction drawn in law here? Or? Thank you. Chairman. Minister go behind.
Maybe Minister, if you ask, it's a point of order.
Oh.
The definition was already amended in consideration of that amendment. So what's captured in the amendment is a special temporary employee. The definition is what went through the amendment that the committee went through. And therefore, any further reference to that provision in the bill with a temporary employee, that no longer applies in this instance because that has already been amended and the committee has adopted that amendment. Just a point of order, no, Minister, maybe you
under which standing order now, which standing order now restricting?
I'm not talking about a standing order. I'm talking about this, the definition here in the bill. We're making reference to the government. That has since been amended and substituted, which the committee voted on earlier.
But the
definition of special temporary employee That's a definition now that we are considering here, not what's in the original principal bill.
Correct. So now we're dealing with as amended.
Yes.
The clause as amended.
That's correct.
And as amended includes
Yes.
what has been approved.
Yes. So we are voting on that amendment.
Correct.
Or considering comments on that amendment which the committee has considered and passed.
Yeah, so we have passed the amendment.
Yes.
Now we're considering the entire clause as amended.
As amended.
So the word as amended includes the amendment. You can't
Absolutely. So
divorce
no,
the two.
it has any further reference earlier to what's already repealed is no longer applicable in the consideration of the committee.
If that has been removed, it's no longer part of it. But the inclusions are still part of as amended discussion.
But it's already passed, well, as amended.
As amended opens it up for further discussion. Only those parts of it that are removed cannot be discussed again.
Discussed. Minister, thank you, Honorable.
Chairman, I follow you very much. So that is still alive, as amended, that particular terminology under that special temporary employee, where it refers to employee of the government. So I agree with you that in page 3, I think we may have already voted on that contract of employment here. Yeah? So what does the question that I'm asking is that, so these are employees defined as those within the civil list or out of the civil list? And now what we are referring to in that, I have no more question. Mila ko ask him.
Okay. Thank you, Honorable MP. Yeah, Minister.
Thank you.
Thank you, Chairman. Thank you, MP for Senator Honera. The position of a political appointees are currently in the manpower establishment.
Thank you. Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the, MP for Central Honiara for that question. If you look at page 3, after say employment means employment in the public service. You go to Crown Proceedings Act and Interpretations and General Provisions Act. You will see that public service means the service of the Crown in a civil capacity in accordance with the Constitution. So answer question, it's in the civil capacity and as a civil list. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Honorable Leader of Opposition.
Yeah, thank you, sir. We move below definition of statutory office holder and the part law in below that definition, which is in parentheses, where we say which person may also hold a position in the establishment and perform functions of that position that are in addition to those of the statutory offices. Give us an example of, I'm thinking ombudsman, some of those statutory positions here. Do they normally also perform functions outside of their statutory responsibilities? Thank you, sir.
Thank you, Honorable Leader of Opposition. Honorable Minister, Honorable Attorney General. Honorable Leader, can you repeat yourself, please? Oh, sorry. He heard you, I didn't.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for that question. For example, the Attorney General is got statutory duty, and we also got ex officio duties where we parlo of Nara Act. And thank you.
Thank you, Honorable Leader.
I would take it, sir, that if Attorney General Chairman Law Kasi, for example, well, that's also a statutory function established by law. You wouldn't be conducting it, well, you wouldn't be performing a duty that's not specified by a law, so it would still be statutory, would it not? What about the other statutory office holders? Would it then permit them to also also to doing any other tasks that are not specified by law, either their law or some other law. But even if it's some other law, it's still statutory. Thank you, sir.
Thank you, Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition. A number of permanent secretaries have statutory functions, and some of them are not, they are just administrative functions. And so this one sort of covers that one, which they are not, as you say, in addition to those statutory functions of the statutory office. Like for example, PS Law Finance has functions under the Public Finance Management Act. Then he has additional functions where Public Service Act and Putum to in terms of delegated functions or other functions where administratively him are performing. So that's meaning him covering that definition him covering. Thank you, Mr. Chairman.
Chairman, me worry Blumina is...
Honorable Leader.
Yeah, thank you. Worry Blumina is that we might have statutory post holders suddenly on all sorts of boards and doing all sorts of things. And also, so I'm good to, especially our constitutional post holder here. I mean, like I'm not for concentrate because, you know, their independence and impartiality and all something, yeah, and go with, you know, the person holding that position is the person ensuring independence of their particular office. But if that is unlikely to be roped in under this definition, then I'm not really an issue. If it is just broadened to include other administrative functions, no more. Thank you.
Thank you. The Honorable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition. For that question, I get your point. Yes, the statutory functions are not paramount to answer, and they will prevail. And so whatever the protection is given there, I don't think any administrative ones would try to override him on statutory. It's a primary function below that office. Serves as the main terms of reference. So, example, when you make a decision to grant a license, you have the legislative framework that you must comply with him, for example. So you cannot use him with administrative only for trial. Those would be irrelevant considerations under a judicial review claim. Thank you, Mr. Chairman.
Thank you, Honorable Attorney General. Honorable MP for Central Honiara.
Thank you, Chair. Chair, this is one very important point here. I may like for Drome come along another very important definition along page 5 here, performance and conduct principles here. In particular, law choice that we have always made, every time we write a bill, legislation, when it comes to creation of board, first people in choosing, same people. One valna you ye ji, naraman humo you. No, not you valno. Yeah, motion. Yeah. I'm just wondering whether you have conduct some kind of an assessment on this, Minister, so that you may leave AG baralo function claims elevano. And PS Finance, for instance, 12 money every time we are looking 12 every board no matter whatever board you create him lawyer first ex officio 12 money now. I mean 12 position and not money, those two positions. So in the context of that, very important definition, principles law or phrases law here. Have you conducted an assessment to see effectiveness of performance and conduct along over some of these established positions here? that somehow we drafted them into the statutory functioning. Just as well, you mean, taken clerk lo parliament, go lo chavala body, and now anything by him happen lo parliament, yes, just some kind of assessment or your feeling no on this, Minister. What have we got out of it? And then maybe we may start to leave more the positions here, make more concentrate now. Let them manage their own department emotion and find the best branch out for Save Lord's territory boards. Your comment, Minister. Thank you, Chairman.
Thank you, Honourable Minister.
Yeah, thank you, Chairman. Thank you, MP for Sarahona. Most of these people are under contracts and contract law there, companies are such positions and come under contract performance. So most of the contracts for them maintaining what now some of the positions that they can be part of in terms of the committees.
Thank you, Honourable Minister. Honourable MP, Central Honiara.
Yes, it is in relation to their contract. I'm really looking at how their interactions within those statutory boards here, and whether or not it makes a difference. Because every now and then, when the choices have to be made, it seems to fall on the same positions every now and then. Have we conducted some kind of an assessment on the way that we have pull some of these positions here into this statutory responsibility. Thank you.
Thank you, Honourable MP. Honourable Minister.
Yeah, thank you, Chairman. Thank you, MP for Honera. We take note of all comments. Thank you.
Thank you, Honourable Leader of Opposition.
Yeah, thank you, sir. Just again on that statutory office holder thing and the wording within parentheses here. So I'm saying which person may also hold a position in the establishment. If you go in addition to those of the statutory offices. So this is more than the reference where the Honourable Attorney General Hemi Mekem first time, where Hemi Attorney General and also Chairman Lokasi, Chairman Law Anti-Money Laundering Commission or Pogatnar or something here. This is a person who holds a statutory office and a position in the establishment. What kind of person here? Do we have such persons, sir? Thank you.
Thank you, Honourable Leader.
Director of Immigration, example. So Director of Immigration, opposing establishment, but he's also statutory.
Thank you, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition. So, like, for example, in the establishment, you have the Director of Immigration as an establishment. It's also a statutory position. Now, so that reference could also be applied on that one. Thank you, Mr. Chairman.
Honourable Attorney General. Any other comments?
Yeah, okay.
Leader of Opposition.
So thank you. That makes sense. But the part where he say, perform functions that are in addition to the statutory offices. So if Director of Immigration and performing what statutory functions, Office of Director of Immigration, no. But then functions that are addition to that, more.
Thank you, Honourable Leader. Sorry, Honourable Attorney General.
Thank you, Mr. Chairman. Thank you, Leader of the Official Opposition, for the question. Those are the reference to administrative functions. It's in addition to that statutory function. Same head of a unit, a department inside law, Ministry of Minister of Commerce, Immigration, Industries and Labour. So he's part of that. So those are additional functions as to the, in addition to the statutory function of a Director of Immigration. Thank you, Mr. Chair.
Thank you. Any other comments before I put the question? Honourable Leader of Opposition.
Yeah, thank you, sir. Time mo the ministry come up your bills committee, sir. We provide them lunch, yeah. So me high hope na Minister you look Mr. Smiley lunch must be located in Venice. But anyway, sir, law definition law transfer where meaning appointment from a position under one commission to a position under another commission. This was a matter I raised with the ministry come up here. There was a particular case where him right come as part of evidence, him right come, where he received him advice. He was a police officer, senior officer, then with a law degree, and then he advice he received was to by him still preserve him long service benefit will him under law police, and then move across into I think independent commission against corruption. But then subsequently found out that him start new more now, entitled for years of service because him resigned. But although that was the advice given to him, so it's a situation we must avoid him where there are transfers. The second scenario, sir, is with regards to the top echelons of the civil service. You may contract them all and so if say a civil servant, senior civil servant, deputy secretary resign or contract them lapse and no resign, so him go from public service, then him go TISA, him go headmaster and go Lonara service more teaching service commission. Again in that kind of situation, or vice versa, coming from education commission, teaching, coming to public service commission. In those situations, how by preserving now the years of service that them still recognized, so they're rewarded for their long service. Thank you.
Thank you. Honourable Minister.
Thank you, Chairman. Thank you, Leader of Opposition. So this issue of long service benefit, it's a policy matter where the Ministry will look into this time. I think we have a lot of issues that relate to the long service benefit, and currently the Ministry is looking into those issues. Thank you.
Thank you, Honourable Minister. Thank you. I will now put the question. The question is that clause 6 as amended stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 6 as amended therefore stands part of the bill. We'll consider one more clause. It's a straightforward one. Clause 7. Does any member wish to comment on this? There's no amendment to this, so that can be disposed of very quickly. Clause 7. Any comments on that clause before I put the question? Thank you, Honourable Leader of Opposition.
Thank you. The application, this one of clause 7A, let me clarify sub-clause 2. So say irrespective of whether the employee's employment is probationary or permanent or on contract or fixed term appointment. Later on, the bill may open them up to volunteers. And but here, perhaps we should include like interns, or not just interns, but experienced persons, but outcome volunteer. Should they be roped in law here, law 7 subclause 2 here? Thank you, sir.
Thank you, Honourable Minister.
Thank you, Chairman. Thank you, Leader of the Opposition. Issue blow this one, address blow clause 14 of the bill. Address blow clause 14 of the bill.
Clause 14. Thank you, Honourable Minister. Any further comments on the clause? Otherwise, let me put the question. The question is that clause 7 stand part of the bill. Those in favour, please say aye. Those against say no. I think the ayes have it. Ayes have it. Clause 7 therefore stand part of the bill. And the shortest clause in this bill is clause 8. I think I'll need to put that question. Clause 8. Any comments on clause 8 about Parliament? Thank you, Honourable Leader of Opposition.
This one, no apply law member of National Parliament, but I think by apply law Speaker or automatic.
Speaker is a constitutional post. No, sorry. I don't think Tony Zero can reply on behalf of the Speaker. This act does not apply to a person who is a member of the National Parliament of Solomon Islands. No comments on that. I mean, apart from your question, it doesn't apply to. I'm not a member. The Speaker is not a member of Parliament, so it doesn't. But he's not a public officer.
You know, so many oath here.
And let me put the question. Sorry, Honourable Attorney General.
Thank you, Mr. Jacheng. I'm just okay. So the clause 10 so the following provisions of this act apply to constitutional post office holders, excluding so I'm just trying to look at the reference to the Constitution here.
Sorry, Mr. Attorney General, we have yet to come to clause 10.
No.
Oh, but yeah, okay.
In terms of the reference to the Speaker, and also understand it's a constitutional post holder, so you will see the reference clause 10 makes reference to constitutional post holders. Maybe we'll come to that when in terms of this one is for parliamentarians especially, so Speaker who is not a parliamentarian is not covered under clause 8 for the application you have. Thank you, Mr. Chair.
Thank you, Honourable Attorney General. Any comments? Otherwise, I'll put with the question. The question is that clause 8 stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. The ayes have it. Clause 8 stand part of the bill. And with that, with your indulgence, I will suspend. I will suspend the committee, and we'll resume at 2 o'clock sharp. Thank you.